Hi, ladies and gentlemen. We are back with the SAP IP Business Talks. Some housekeeping rules for the moment. So this is a live show. That means we are happy to get questions from your side or comments during the discussion. I will pick it up and bring it to the show. And so we are happy to discuss your questions and your comments. Today, we talk about Cleantech Innovation and how to protect them with IP. There are very specific issues around green tech and clean tech that are typically quite complex issues and also from a technological standpoint, very diverse. So it's a tricky field, and I'm very happy that I have today Hermione Thompson with me and John Leeming. Both are from JA Camp. Welcome to the show, Hermione, and welcome, John. So how did you came into that, let's say, a bit strange field of IP?
John? Hi. So I have been working as a patent attorney for about 14, 15 years now. So my background was in general engineering at university, and throughout my kind of university career, that meant I got to look at a relatively wide range of different engineering disciplines, which were very interesting. And at the time, I worked in my summers and in my gap year for a kind of civil and structural engineering firm, which was really interesting, but also very useful in helping me to understand that that's not what I wanted to do. And so, as the end of my university career approached, I kind of was looking at the different job opportunities that were out there and came across the IP profession at a careers fair. And just the thing that really appealed to me, and I think that appeals to a lot of people who end up in IP, is the variety of the technologies that you get to look at, over the course of a whole profession, but just even day to day as well. And so being able to kind of look at different things day on day seemed quite vastly different to the experience that I'd had in the, the brief experience that I'd had in the civil engineering side. So that really appealed to me, and that's how I ended up joining the IP profession.
Okay, thank you. How was it in your case, John?
Well, not too dissimilar a story. I did a physics degree many years ago and concluded during that physics research was not really what I wanted to do, but I wanted something a little bit more connected to science and technology than becoming an accountant, which seems to be the routes that a lot of my contemporaries took, and casting about for alternatives came across the IP field, which in the late 1980s was rather smaller and less prominent than it is now, but it's been a very interesting few decades.
Yeah, thank you. So today we have also two green tech IP expert contributors with us for the discussion, Friedrich Linhardt and Russell Wooliter. Thank you very much for joining us. And when you are interested in the topic, you will get this link also in the discussion on LinkedIn. This is our industry focus with the current with the current market study about IP in this field, and lots of background information about IP in green tech and clean tech. So my first question to you, I said it already in the introduction, it is a terribly complex issue, very diverse in technologies. So typically such innovation combines, lots of different engineering fields and materials, software, manufacturing processes. So also environmental issues. How can a user of the IP system, let's say a company, a startup, a deep tech company, a scale-up company, how can they identify, so to speak, the technical contribution which they would like to get protected let's say with a patent. So what can they do?
Yeah, so I think one of the first things to kind of take on board, and which you've touched on, is the fact that there's such a huge breadth of technology and companies in terms of where they're at when we talk about clean tech. So even though there might be certain issues that are, that apply to all different types of clean tech company, often, they might be at very different stages dealing with very different types of technology. So there isn't necessarily a kind of one size fits all. But having said that, there's a lot of considerations that that would need to be taken on board that would be similar. So one of the first things is making sure that key technologies are protected, and part of that is actually identifying the technologies that might be protectable within the business. So a part of this is basically invention spotting internally. So you need to make sure that your workforce is educated in terms of the relevant people, so the designers, the inventors, the engineers, the people who are actually coming up with the developments and technology, knowing the importance of IP, knowing the how to identify inventions, and
excuse me. I mean, isn't that one of the biggest problems? I mean, we want that somebody who has more or less no clue about IP should think about, is that an invention? Might that be an invention? So let's say software or whatever. A technology guy is working and they say, technologists, engineers, they always say that's trivial, everybody knows that. Even when they make a very significant contribution, they just, I mean, that's not that big thing. Yeah. So how can we implement that? Is it just education, or should there be also a kind of support to find these sweet spots where something is really important and should be protected?
So I think that you need, the first thing is the education in place so that you teach the workforce to actually bring forward the inventions that they come up with. So if people are working on things and they have no idea that they're supposed to bring that to someone, then that can just get lost in the mix. What you really want is to make sure that the people who are working on developments and the people within the company in general understand the importance of the IP strategy overall, or at least understand that if they come across something, if they develop something, if they are working on something that may be relevant, that there are the relevant there's the relevant information in place and the channels in place for them to know what to do with that. So really what you want is to have procedures in place. Sometimes those might be more formalized in certain scenarios. There's a lot of clean tech within, for example, within universities, and they might have a more kind of structured procedure in which inventions might be effectively kind of reported through having kind of internal invention disclosure forms, which then get kind of passed up the chain. But ultimately what you want is for people who are doing the development to be aware that they need to try and identify and bring the relevant technology to the attention of someone who then might make a decision about it. So okay. The first things first is
that means when I understand you correctly, that means we don't say look for inventions, because then they have the burden to make a first evaluation whether it is an invention or not. So now we say it should be relevant. So at least it should be relevant, then bring it to us and we make the evaluation. Is that correct?
Yeah, so I think that there's a difference in that process in terms of the people who are doing the development and coming up with the technology, and not necessarily the same people who are making the decision of whether or not that ultimately ends up being protected. Whether or not it's ultimately protected as part of the overall business strategy and the kind of higher decisions of, whether or not, for example, to keep certain technology confidential, whether or not to patent something, either for one individual concept, or whether or not you're looking at a more whole or complete kind of invention and including a few things together. Those kind of decisions in terms of what actually gets patented and what gets protected not necessarily always, but aren't necessarily made by the same person who's coming up with the developments themselves.
Okay, so people should be aware of relevance, of economic impact, and they should understand that exactly that makes it interesting for IP, at least. And they should integrate whoever, let's say somebody who makes decisions about IP, hopefully based on a strategy. But basically it is the relevancy and the economic impact that should be clear. Please come up with that and talk with us, because that this relevancy, this economic impact makes it interesting that we think about IP. That would be the message, right?
Yeah, and there's certainly companies, especially those on the smaller end, but not necessarily even kind of startups and things, where we've spoken with them and we've spoken with inventors and either gone in and done talks where we actually talk to the inventors and the people who are coming up with technology to try to help them understand the importance of protecting their IP and understand the different kinds of intellectual property that might be available, not just patents, and then talking them through the kinds of things that might be patentable, in a very general level, but just keeping it at the forefront of their mind so they understand that. And what's most important is that then they can take that away. And it's not that they then make the decisions, it's that they then take that to their manager or to the relevant person or submit a form, however it is that information is then captured from their side, so that can then be put into the decisions of whether or not to protect it. And I think that what's really important as well is that there's an understanding that that's an ongoing process. It's not just that you come up with a development and then get something patented and that's the end of it. It's you've got 1 year in which you might make further filings and you can include further developments in relation to that invention. And it's important for people to understand a bit about the process, in as much as is reasonable and possible, so that they can then also know that if they actually come up with a great advancement within, say, 6 months, that they don't want to then just go and kind of be like, oh, let's put this on our website. They want to keep that secret. They want to make sure that they understand that things should be kept confidential, and that they then also, pass that up the chain of, hey, look, there's another development here in relation to what we were doing. Can we protect this as well, or we think this should be included? And so, making sure that they understand a bit about the process is hugely beneficial for that.
Yeah, we had a wonderful discussion lately with Maria Boysover-Weinans, and we talked about the on LinkedIn. We talked about the question whether company representatives have a feeling that they make IP decisions, and most often this is not clear to them that this is an IP. So, for example, putting something on a website is a de facto IP decision. But obviously, they are not clear about it. So this is not clear to this company representative that it is one. And I think that could be or should be a kind of this training, or of that there is a deeper understanding that typically you make 10 IP decisions every day, and that is not clear to the people. So they say, okay, an IP decision is whether I want to file a patent or not, but all these other decisions, a contract, giving a presentation, whatsoever, that are IP decisions. And I think maybe we should not call it like that, but it is de facto so, and there should be awareness about that, right?
Yes, I think again, this is not specifically a green tech issue, but people need to understand that the level of innovation for a patent is not that high, and I particularly in the UK, people have a tendency to sort of underplay their own achievements and think that something is not that patentable when frequently it would be. But a concentration on the sort of gains that an invention can provide, particularly in terms of sort of saving energy or generating energy or whatever, is a good focus.
Yeah, absolutely. The technical or economic impact. So Friedrich has a wonderful question here. he says that basically we talk about IP harvesting and protection, yes, of course. And now he says, is there or are there specific challenges in green tech for this process? And we said already that the complexity, these life cycle issues in clean tech are relevant and make it complex. Are there other aspects on green tech which makes that specifically tricky?
A lot of green tech inventions that I've seen have come out of sort of sponsored research in some cases. So you need to be careful about the terms of a government grant or some other institute grant for that research, and also and the application process for such grants, whether they're properly confidential, so that they don't, you don't give away your possibility of getting a patent by applying for a grant in some way. And then, you
contractual environment, so to speak.
And you've got to sort of factor in the cost of patent applications into sort of grant applications and business plans there. Also green tech has a lot of government regulations in some areas, and those need to be thought about. And
and sometimes I have the feeling. So when we made this study on about IP, the business of IP in green tech, that many IP experts, but also representatives from companies, don't have the feeling that there are in green tech. So this is such a diverse field that John, we get in contact about a photovoltaic issue, for example. So that can be chemistry, that can be electronics, material. That makes it also quite complex. That even the guys who are in that field not often identify themselves to be in that field.
Yes, and there are a lot of people working on environmentally friendly developments in traditional companies. It's not just sort of startups that are concentrating solely on green tech. There are big companies that have pushes to improve the environmental standards of their products.
And that could to answer the question from Friedrich, that could mean that they underestimate, for example, the patent literature, so the freedom to operate issue here, because when they just make that environmental friendly because they want to improve the product or this aspect of the product, they are maybe not aware that this could include a huge amount of patent literature in this field of eco-friendly whatever, which, because they don't identify themselves as a green tech a company. So it's a world in which you jump in just with one business decision that we want to have that whatever recyclable or something like that. That leads me so FTO and this kind of questions that take a lot of time. So typically, and IP is also seen as something which reduces speed, and especially when we talk about, let's say, scale-ups or startups, these companies typically want to move fast, have to move fast. They have a certain burn rate of their money, and they want to go as fast as possible to the market, enter the market, or scale up in the market. So what can IP do in such situations when, for example, when they want to know now, so they jump into a certain market, certain region, so jurisdiction. What can IP do to support the scaling process?
So, I think that with the overall patent strategy, that needs to be considered at all stages, right from your early development and whilst you're scaling. And one of the key things is kind of the ongoing consideration of your patent strategy, and including that with the decisions that get made whilst you scale. In terms of the patenting process potentially slowing down the scaling process, that's not always the case. There are things, and this is really where, you know, there are green tech specific things that you can do to speed up your patenting process. For example, for a specific application in the UK, you have the Green Channel, which is, you know, a relatively straightforward way of speeding up the way in which the UK IPO will get back to you. I think they should get back to you within a couple of months if you file a request for accelerated prosecution. That will slightly depend on when you do that, and they will have to delay a bit if the publication hasn't occurred, for example. But there are ways of speeding up prosecution, not just in the UK, but there are various other countries as well. For example, I think Japan, Canada, South Korea, they all have green tech and clean tech specific ways of accelerating prosecution. But that should be considered as part of the overall strategy as well. When you are kind of scaling or in early development, there can be instances where it can be extremely useful to try to push to have a patent granted as soon as possible. For example, if you are trying to get investment, they may be more interested once you have a patent right granted, because there's certainty there over what the actual scope of the protection is. But there might also be consideration in some instances of actually slowing things down. The costs can come pretty quickly, and if you're speeding everything up to try and go as fast as possible, then that can mean that your costs are coming through quicker, which may not actually align with the funds that you have available. And additionally, there is an element of sometimes having things continuing and keeping on going. There's a benefit to having patent pending, to having something that's actually during prosecution. There's more flexibility. You still have scope for changing that. So there can be pros and cons to trying to speed up or slow things down. But ultimately, what you want to do is make sure that your patent strategy kind of keeps in mind your scaling, and so that you're considering both things together. So you're considering how you kind of approach your patents on an individual level and as a portfolio as a whole with the scaling that you're doing. So those decisions aren't made kind of in isolation.
I think another important consideration is the sort of ultimate aim of the company, and that a lot of startup companies are looking to be bought sooner or later, or looking to have an IPO and to grow into an independent company, and different strategies sort of apply there depending on which route that you're looking to take.
Yeah, absolutely. And what is the interest of the investors, for example, and on which we had that discussion with Chris DeMoni from Bird & Bird 2 weeks ago. He works in the Bay Area for fast-growing tech companies there in San Francisco, and he said that it is very critical for them to fulfill the interests of the investors, obviously, and they are interested, for example, in the UPC situation in Europe, even in the United States, and the investors in the United States have really an opinion about IP strategies. So that's really fascinating. So there's from one of our ambassadors, Udo Gennari, there's an interesting question, which he says, Hermione, you said that it is not a one-stop thing. It is not a snapshot. So it's a continuous process. So he asked the question whether you organize or you support companies with a kind of monitoring service, or to help them. I think here it is about a kind of continuous FTO, for example. How do you interact in concrete cases with companies?
Yeah, so I mean, often companies are pretty well aware of competitors and third parties that are particularly relevant to the work that they're doing. In terms of ongoing monitoring, one thing that I've certainly done before is continually looking every few months at patents which have issued in the previous several months relating to a specific competitor, for example. one of the reasons it's really useful to do that on an ongoing basis based on kind of more recent grant is because if there is something that comes up that looks like it could be problematic, for example, in Europe, you can consider filing an opposition within your 9-month period. So that can be a very good way of identifying an issue and then doing something about it relatively proactively within quite a short time frame to see whether or not you can either have the patent either revoked or at least amended so that it's no longer necessarily the same level of problem. But that is certainly something that we do. That tends to come about when a company has already identified that there's a problem or an issue with a specific competitor, and then have ongoing watches. But you could, of course, set something up more generally if that is what you wanted to do. There's just obviously anything where you do kind of broader searching and wider searching, you can increase your cost. So it's always a balance of what the cost is going to be compared to the risk and the level of security that you might get from that.
Got you. So there is an interesting second question from Friedrich, and he says that that patent applications, so to speak, they have a certain effect on, for example, investors about trust and credibility. So it is always a kind of objective quality indicator whatsoever. When a patent application is a wishing list. It is. I mean, I can apply for whatsoever, and it's a bit funny, but interesting enough that investors typically see it as a quality indicator for technology, even when it is just an application. So what is your opinion on that? Is that a recommendation, file more because that helps more? Or should we also think about, will that be ever granted? And if so, is this forbidding right at the end something worth? So do we really forbid something relevant with such a patent and so on? So what is your position on that?
I think it varies considerably amongst investors. Some of them are sort of a bit of box ticking, that they see that the patent application has been filed and move on to the next issue. But you do occasionally come across investors who are a bit savvier and really look at what's been filed, and they sort of need assurances that yes, it's valid, it hasn't been prior published, that and there's good coverage, and that there is a process for keeping watch on developments internally and externally to monitor it all. So just saying we've got a patent application is usually not. It can be enough, but it's got to be defensible. You've got to be able to justify that it's a decent patent application or covers the right stuff. Perhaps a portfolio is beginning.
I think there's a clear benefit of having that as part of something which is a clear overall IP strategy, not just we've applied for one patent application, but more in line with I think it's Friedrich's comment, but in terms of actually having the trust and credibility there is about saying, we have seriously considered this. We have looked at what we can put in place to protect the assets of this company, which is in terms of trying to obtain our own protection where it is relevant, in a measured way and in line with what the budget that we have, and also looking at how we can protect against third parties' IP. And so, that really will vary company to company, and also depending on what stage you're at. But making sure that you have considered those relevant things for the stage and the which you're at.
I mean, this strategy thing that matches very good with a question from Henry Wang. He is our ambassador. I think he's at the moment in Hong Kong. And I think that goes into the direction of not just adding patents, having a meaningful IP strategy, and this is much more than a patent strategy. And he asked the question: is that something which really leads to a higher level of competitiveness? So how can we convince also decision makers that it is so? So what would you say?
Well, the IP is always about protecting some innovation. So if that innovation enhances your competitiveness, then securing exclusivity to it or enabling a new revenue stream through licensing can, certainly improve the position of a company. But it does need to be founded on good inventions in the first place.
And I think it also brings it back to the first question, in which we kind of didn't necessarily touch on too much, but in terms of the people making the decisions of what's actually protected as well. So you need to have the actual innovation there in the first place, and then the decisions getting made so that the actual inventions that are being protected are the ones that are most relevant in terms of either protecting the key and the core elements of your own innovation, but also looking at what necessarily like competitors are doing. What do you want to make sure that you are kind of avoiding them stepping into certain territory that you're already doing?
Got you. Just to mention, Katja, I would really like to bring up your question, but I cannot see it full. So just make it shorter, then I can bring it to the show. That's too much text. And also, Friedrich, make it shorter, otherwise I cannot integrate it, and I even cannot read it. So John, your expertise is especially on solar panels, and it's one of your fields of expertise, and that was also part of our meeting, our first meeting. And so that is a wonderful example for this extremely complex technology, and the tendency that technology becomes more and more complex. So this rising of complexity is an issue. And we have cell architectures, we have the semiconductor materials or other kind of materials around that. We have manufacturing methods and processes. And on top we have system integration, and we have systems of systems, and so on. And so the question is, when a company works in such a field, so how can we help to make clear on which kind of level of layer is the most important aspect for patenting? So you said it's a right which gives you exclusivity. So that means I have to understand as a decision maker which kind of exclusivity on which layer is helpful for my business. So how can you help here?
Well, it's always got to start with the core of the invention and where that is, and then you sort of build from that. And it's often convenient to sort of structure that into a claim set, which starts with the sort of smallest independently new and inventive component. Perhaps that's a solar cell, a small cell and a geometry or something of that, and then build that up to claims with panels and with systems and the control aspects around it if they're relevant, and claims to the sort of manufacturing processes and the use cases if there are specific use cases, and really, from a patent point of view, at least at the early stages, we try to be as greedy as possible and lay claim to everything that we can think of, upstream and downstream. And then later down the process, when the market position and the company's strategy is solidified and the prior art position is clearer, then you can sort of redirect the patent application in whichever direction is then necessary. I mean, too often you sort of see situations where client has come into an initial situation with this is what we are going to do, and patent application is quite narrowly focused on that, and then 2 years later they sort of say, well, that doesn't work really, and we're doing something else, and you think, well, that's not really in the scope of what you said to start with. So it's very important for the attorney at the beginning to give room for maneuver later down the line.
So Katja was so nice and made it a bit shorter. So she's an MEPLM alumni from SAPI, and she asks a very smart question here, which is an issue about the innovation process. So typically, IP representative says we would like to be as early as possible in the process. So obviously nobody wants just to get invention disclosure thrown over the fence, which is maybe meaningless, maybe good, maybe the wrong point. Yeah, it's just an invention disclosure, which is written from somebody who has typically no clue about IP. So yes, we want to be integrated quite early in the process, but how can we make sure that, especially in dynamic fields, that at the end we protect something which has a commercial value and has a certain strategic component? So is that what Hermione said? Is the IP strategy the cornerstone? Is it the innovation process, or what we call at the end the innovation, and not just this one technical issue? So what would you say? What kind of support can we give here? Can you give?
I think this is a sort of conversation that we have to have with the business, and sitting outside any business, we can't leap in and say this is what you should do. We have to listen to the business strategy and the market position and all these kind of things, and then we can explain what the IP can do for it, and together we can decide where it goes. And jurisdictions in particular.
Yeah, and ultimately we have to be having discussions with people who know about where the business is now and where it wants to go. So what the business, the kind of aims are, like John was saying before, and those discussions inform not just kind of what the IP decisions are for each individual thing in terms of which jurisdiction, but also, where research might be focused and things like that. And the people who are making the decisions ideally, would want to be asking a number of questions around this in terms of, for jurisdictions, which markets are relevant for them, which markets are relevant for their competitors, considering how much, investment is appropriate is to do with, what budget is available, what innovations do we have to protect, how core and key are those innovations for the actual business, what revenue can we get out of those? So we can have the discussions and ask the questions and try to get the answers to help kind of guide what that is. But ultimately those decisions have to come down to the people who have the knowledge in the business of where they're trying to take the business and kind of where the business stands now.
Okay, so what you say is we need an ongoing discussion. So this snapshot thing and these throwing invention disclosures over the fence will not really be helpful, and is not really what creates value at the end for the company. That this integration of IP on an ongoing basis in the business, that is the cornerstone of how to integrate IP into this business thinking. Okay, I have here a question. I can't see from whom it is, but I think that is very interesting. And this is this classical issue between trade secrets and let's say patents, and this tendency that sometimes companies say, yeah, we would like to keep it secret, but unfortunately they don't have really measures for that. They have not really a management practice which allows to keep things secret. Here it is more about the demonstration of value. So how do you deal these trade-offs between the discussion about trade secrets and the discussion about, let's say, patents?
Yeah, visibility of the invention is often a very key thing. One of the questions about whether we should patent something is always, well, if your competitor infringes it, will you ever know? If it's some sort of parameters in a manufacturing process, is that going to be visible in the end product? Could it be reverse engineered from the end product, or is it just going to improve their efficiency and be invisible to the outside world? In which case, yeah, trade secrets is probably more appropriate than patents, but you can't just say this is a secret and that's the end of the matter. You've got to have management processes around that record what you consider to be secret, and that make sure that the people who need that information in the company understand that it's secret and are bound by appropriate NDAs and documented. And if you have that process around and you do have some documentation there, then that can be something that you can share with investors under the right terms and without giving them the actual detail of the information, but explaining that we've got this system, we've got this database of parameters that improve our manufacturing process, we've got a trained machine learning model that runs the system, and that can demonstrate the value there. But
okay, guys.
Part of that comes back to the education from the first question, that the people know who are doing the development, that how to actually approach IP as a whole, and part of that is the tracking of the innovation they come up with.
Yeah, and here this is the management process behind that. So we have in Germany the DIN 7706, and we have the ISO 6505, which helps to set up processes according to these standards, to show, for example, to investors that you have processes in place which have a quality standard on an international level, which makes sure that it is at the end really a trade secret, and it's not just that you say it is a trade secret. So, John, one question just out of curiosity, because we have a very dynamic environment in these solar cell technologies, and obviously solar cells are a very important part of green tech and clean tech. And so we have different developments in tandem solar cells and perovskite and all these things. So and that also we see a certain performance improvement there, and at the end we need scalable production of that. So otherwise we have a cost issue, and still we have the Chinese there. We rest the product in the market. So what can you say to companies who are in that field when they want to create a defensible patent portfolio and when they want to attract investments? Is there something specific in that field, or is it just the generic, you should have your patents in place?
I mean, the sort of the generic, have the right patents, make sure they cover the right things, make sure they cover the territories, the right territories, whether that's your manufacturing competitors or your customers. For something like solar panels, which are pretty ubiquitously useful, it's probably easier to look at the manufacturing side of thing, which is pretty heavily concentrated in China, although there's been pushes in the US to improve manufacturing there. But yeah, I suppose the thing to think about is the future development as well, and then, as you say, with different semiconductor substrates and perovskites and things coming forward, you need to sort of make sure that the patent applications, I mean, if they are for a specific composition for one of those, then maybe not, but in other situations, geometry or control electronics might apply to a whole variety of different types of cell, and you've got to be careful not to restrict yourself to one base technology.
Okay, what leads us back to who knows what is the invention, who makes the decision. So how to convince the examiners, how to tell the right story about the right invention to get the exclusivity which you needed. Okay, thank you. Yeah, that makes totally sense to me. So thank you so much. We have, unfortunately, some questions still open. It would be great when you two guys have some time to answer to that in the LinkedIn chat in our after show. So thank you very much for joining us today. And we will be back, ladies and gentlemen, at the 16th of September, simply because I'm on vacation for the next 2 weeks. And then we will talk about UPC with Christoph Augenstein. And I hope that you enjoyed this show. Thank you very much, Hermione, and thank you, John, for your insights and deep dives into the field of clean tech IP protection. Thank you very much. And to the audience, thank you and bye-bye. See you.
Thank you, Alex.
Okay.